this week touches upon California's constitution in a number of different ways. So as we try to understand California government and politics today, it's important to understand a few things about this document since it establishes the rules of the game, if you will, for government in the state. So this brief file is meant to give you a little bit of context regarding the state constitution and help you to understand the key ways in which the California Constitution differs from the United States Constitution. Okay, so what's the purpose behind California's Constitution? Basically, it's to establish a form of government in the state that meets the principles set forth in the United States Constitution. The U.S. Constitution established a system of federalism in which both the national government and the states had their own powers. We'll talk more about this in Module 5, but federalism was a key invention of the Constitutional Convention in Philadelphia in the summer of 1787. The delegates to that convention were interested in establishing a more effective national government to address some pretty profound problems that had sprung up in the years that immediately followed independence from Great Britain. At the same time, states were where most of the governmental power lied after the Revolutionary War. And citizens as well as political leaders, they were hesitant to simply hand over power to a distant central government. So the solution was to create a mixed system in which power was divided or shared by different levels of government. So Article 4 of the U.S. Constitution guarantees that all states shall have a republican form of government. Now in this context, the word republican is not referring to a political party, but rather a representative form of government, which gets at this idea of the citizenry ruling indirectly through elected officials. State constitutions, like the one adopted by California, are frameworks for guaranteeing that republican form of government. They are a state's basic law, spelling out the different institutions of government and how they are supposed to operate. They also specify government powers as well as the people's rights and liberties. State constitutions are really important documents because it's at the state level that so many critical government functions are performed. States take the lead in all kinds of important policy areas, including public health and safety, education, administration of elections, criminal justice, transportation, and business regulation. So one way to get a better understanding of California's Constitution is to compare it to the United States Constitution. California's first constitution was ratified in 1849, just months before the state was admitted to the Union, and just a couple of years after California became U.S. territory following the Mexican-American War. It was a bit of a hurried job to write the state constitution as California's population was exploding as a result of the gold rush, and as the status of California was a bit of a political hot potato back in Washington, D.C., as a result of the continuing conflict over slavery and how it should be addressed in new territories and states. California held another constitutional convention in 1879. The state had undergone huge changes over those 30 years as mining spurred enormous population growth from both internal migration within the United States as well as immigration from abroad, and the completion of the Transcontinental Railroad connected California to the rest of the country. That was huge for providing a foundation, especially for the growth of agriculture in the state. So these rapid changes brought about enormous social upheaval, leading to a state constitution that was much more populist in nature than its predecessor. In terms of length, California has one of the longest constitutions of any government in the world, weighing in at over 74,000 words. This is largely a result of over 500 amendments, provisions that have been added to the Constitution over the years. These amendments deal with far more detailed things than just the framework of government, but also very detailed policy, things like how property taxes are assessed, or very specific sentencing rules for repeat criminal offenders. California's lengthy constitution, with its many amendments, really stretches the idea of a constitution as the basic framework or rules of the game for government. Instead, California's state constitution has become something of a governmental Frankenstein, with a hodgepodge of different laws attached to it. This contrasts pretty glaringly with the United States Constitution, which sticks much more closely to the principle of a constitution that simply establishes a framework for government, but leaves most of the details to be filled in by the ordinary legislative or lawmaking process. While the California Constitution is being amended almost constantly, the U.S. Constitution has only been amended 27 times in over 200 years, with the first 10 of those amendments consisting of the Bill of Rights that were ratified shortly after 1789. What explains this difference is how the two constitutions handle direct democracy, or the ability of the people to rule directly. The U.S. Constitution provides no provision for direct democracy. The people's voice is only expressed indirectly through elected representatives. And the threshold for amending the Constitution at the federal level is extremely high. To amend the U.S. Constitution requires a 2/3 vote in each chamber of Congress, and then the approval of 3/4 of the states. Direct democracy was left out of the U.S. Constitution because the framers of that document were highly skeptical about the ability of the common citizen to make wise political judgments. While they believed that government needed to be responsive to the voice of the people, they thought liberty was best protected by filtering that voice through representative institutions of government, where, at least in theory, cooler heads would prevail. But between 1789 and 1879, the 90-year gap between ratification of the U.S. Constitution and ratification of California's second Constitution, a lot changed in the country in terms of how people thought about representative government. There was a much greater demand for the voice of the people to be heard more clearly and more directly. Rather than acting as wise trustees of the public good, many representatives in Congress, as well as representatives in the state legislatures throughout the country, were seen as corrupt tools of powerful interests. Especially in western states like California, there was a push to try to make government more responsive to the people and to allow the people to have a more direct say. So, for instance, the California Constitution specifies that voters can directly initiate and vote on constitutional amendments. Basically, a group of citizens that would like to see some change in the state constitution can get together and start a petition campaign. If they collect enough signatures, the threshold is 8% of the number of people who voted in the last election for governor, then their proposal gets placed on the next general election ballot, and the voters of California vote yes or no on the initiative. If the initiative gets a simple majority, it becomes a legal amendment to the state constitution. This is one of the lowest thresholds for direct constitutional lawmaking power by the people anywhere in the country, and it explains why California's constitution has been amended so many more times than the U.S. Constitution. Just as suspicions of political corruption led California to adopt direct democracy for amending the Constitution, the skepticism of representative democracy also extends to how the state's branches of government are structured. So, for instance, in California, power in the executive branch is dispersed. This means that executive power is divided among a host of different elected officials. California has 8 separate elected executive branch officials. So while the governor is the highest profile figure in the state's executive branch, he or she has to share power with a lieutenant governor, secretary of state, attorney general, treasurer, controller, superintendent of public instruction, and insurance commissioner. The idea here is that Californians did not want to invest too much power in the governor, so they have different officials handle different executive branch tasks. This adds complexity and sometimes almost comical dysfunction to the executive branch. So just as an example, in the late 1970s, when Jerry Brown, a Democrat, was governor for the first time, he decided he would try to run for president. So he often traveled out of state for his presidential campaign. But California's constitution specifies that when the governor is out of state, then the lieutenant governor becomes acting governor. The wrinkle with this plan is that at the time there was a Republican lieutenant governor who had a very different political philosophy from Governor Brown. So every time Governor Brown left the state, the lieutenant governor would use his powers as acting governor to issue executive orders and take other actions to overturn Governor Brown's policies. So some of these were easily reversed when Governor Brown returned to the state, but others weren't so easy. But it just looked like a mess that California's executive branch policies were changing depending upon who happened to be in the state at any given time. This just gets at how dispersing power in the executive branch among officials who don't have to answer to a single boss can create a chaotic situation. By contrast, executive power in the U.S. Constitution is much more centralized in the office of the presidency. The different federal executive branch officials, like the Attorney General and Secretary of State, are appointed by the president, not selected by the voters, so they have to answer directly to the president. This gives the president much greater authority to shape the executive branch according to his or her priorities than the governor of California can do. Just as Californians thought it would be a good idea to disperse executive power, they also tried to limit the power of legislators by instituting term limits. Although the provisions have changed over time, the current rule is that no one can serve in the legislature for more than 12 years. By contrast, there are no term limits in the United States Congress. As long as voters continue to elect them, senators and representatives in the House may serve for as long as they wish. Finally, like most states, California's Constitution specifies liberties enjoyed by the people that extend above and beyond the liberties guaranteed by the U.S. Constitution through the Bill of Rights. In particular, California's Constitution guarantees the liberty of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and obtaining safety, happiness, and privacy. State constitutional provisions like these are important because they provide an additional legal avenue if you as a citizen feel your rights have been violated. Perhaps you have a civil rights or liberties case or claim that would not pass muster in federal court. However, you can turn to the state court system to apply the provisions of the state constitution to protect your liberties guaranteed in that document. So to kind of sum up, the big takeaway here is that California's Constitution is distinct from the U.S. Constitution in some pretty critical ways that make government and politics in the state operate pretty differently from how it works at the federal level.